Good morning, good evening, good afternoon. There is a lot of misconception about the role of an attorney in the sovereign citizen community, about the fairness of trials in the sovereign citizen community, about the rules of evidence in the sovereign citizen community. And I just wanted to try, I understand that most sovereign citizens aren't going to listen to me because I'm an attorney, but let me just try to give an explanation for all these things. First of all, the procedural rules, especially like the rules of evidence, are designed to keep out improper material. If there weren't these rules, and if you could bring in all the things that you wanted, that means that the other side, the prosecutor or the other side of a civil suit, whoever it is, would be able to bring in all sorts of things that you wouldn't want to come in. It wouldn't be fair to have them come in. Both sides have to play by the same rules. One of the big roles of an attorney is to understand those rules. The rules of evidence are a pretty important thing for an attorney to understand. The role of the attorney is to try to get the evidence you want in to evidence and to keep the evidence you don't want into evidence out. And there are rules in place on how to do both of those things. For example, I know Common Joe wanted just to play videos, and you have to, first of all, lay a foundation for the video, showing that it's relevant, establishing who took the video, establishing what the video is of, when the video was taken. You have to basically lay the foundation for that video. You can't just start playing the video. And attorneys understand that, and people like Common Joe don't. And so when they don't get their video into evidence, they don't know why. They think, oh, the judge is just against me. No, the judge has the playbook, or the rule book, he's the referee, and he says you didn't do the things that you needed to do to get this video into evidence. Now, even if you wanted the video in evidence, there might be other things like relevance. Whether or not he shot the dog, whether or not that was justified, is really the core of the issue. Did he shoot the dog? Yes or no? And if he did shoot the dog, is there a defense to it? And really nothing that he says after the shooting is material to whether or not the dog was shot or it was a justified shooting. So the prosecutor is going to raise evidentiary objections to keep the video out. So two things that Joe didn't do. Number one, he didn't lay foundations for everything, establishing why it should come in and the relevance, blah, blah, blah. And the other thing is the prosecutor established that it shouldn't come in because it wasn't relevant. The procedural stuff that happens before the trial is relevant only for the procedural stuff. It's not relevant to the trial. Whether or not you shot the dog is not established by whether or not the judge denied your motion for a continuance, or whether or not you pled guilty or not guilty or nothing at all. That's not relevant. Remember, the only thing that was relevant for Joe was, did you shoot the dog? That's a yes or no. And if you did, was it justified? That's it. That's all that had to be proven. And the burden for the justification is, first of all, you have to raise it. You have to raise the justification. In some states, you don't have to raise things like self-defense. Other states you do. Some states have a shifting burden of proof on that. Like, once you raise it and you show it by preponderance of the evidence, then the burden switches to the other side, or maybe even a lower standard. Then the burden switches to the other side to overcome it. In some states, the prosecutor has to overcome all that stuff off the get-go, show that there are no justifications, no defenses, like self-defense. But again, if you don't understand the procedure, if you don't understand the law as written, if you try to argue nonsense, if you try to argue like jurisdictional arguments or things like that, you're not going to do very well. I binge watched over the weekend probably 30 or so sovereign citizens in court, trying to do their thing in court. And generally speaking, the judges were very nice about it. They didn't immediately lose their cool. Some judges immediately lost their cool. There's one judge who called it bullshit, and used vulgar language, which I think is behavior that is not very judicial. I don't like that behavior out of a judge. But he's been a judge for like 20 some years, so I'm going to guess that it's not, I don't like it, but just because I don't like it doesn't mean that the judge can't do it, is really what I'm trying to say. But I have yet to see an effective sovereign citizen defense. It doesn't work. Sovereign citizens don't understand the procedure. They don't understand the rules. They don't know enough to know what is relevant to argue and what is irrelevant to argue. And so there is a role. And I've also, there were some that they were calling sovereign citizens in these videos that I watched who were just per litigants. And, they didn't understand the rules. And if you don't understand the rules, you're likely to get crushed by them. Because it's a very rule-centered process. The rules are designed to ensure fairness, but if one side doesn't understand the rules, you can get an unfair result. But the system is not designed to recognize when one party doesn't understand the rules. It's an adversarial system. The judge is just there to make rulings on the objections presented. On the, if it's a bench trial, he'll judge the facts. But generally speaking, the judge is just there when one side says objection and states what the objection is, to say yes or no to the objection, sustained or overruled. That's the judge's job. And so if you don't know what objections to make, you're at a distinct disadvantage, because the other side can get in whatever they want, basically, and you can't get in what you want. So because it's a rule-intensive process, lawyers are, generally speaking, necessary. Now, you may have done a pro per litigation and you may have won, and congratulations to you. But your odds of winning increase dramatically if you have representation. So I hope that makes sense. Trying to argue nonsense out of the sovereign citizen playbook doesn't work. It never works. Every once in a while, you can make a sovereign citizen style jurisdiction argument and have the court say, yeah, actually, you're right. The ticket doesn't say that it was written inside the city limits. I don't have jurisdiction to hear it. But you get lucky, because you didn't look at the ticket. You're just making the sovereign citizen argument, and you got lucky that it actually applied. But 99 times out of 100, it doesn't. And so having a lawyer who understands these things can increase your odds of success. Not having a lawyer increases your odds of failure. And when you're going up against the state, if it's a prosecution, maybe the city's prosecuting you, maybe the state's prosecuting you, maybe the federal government's prosecuting you. But if you are being prosecuted by a government, they have a lawyer representing them. They have someone who probably understands the rules of evidence and the procedural issues. And if you don't, you're at a disadvantage. I can't make that any more clear. So maybe Joe did have a defense. Maybe he did. Maybe he had something that would have saved his bacon, so to speak. But he didn't know how to present it. And from my understanding, he left the trial. So there was literally no response by the defense. There were no objections made to anything that the prosecutor put into evidence, because Joe wasn't there, and no one representing Joe was there. So Joe may not have actually done the thing, or may have had a justification for the thing that he did. But we'll never know, because Joe didn't know what he was doing. And I understand that he might be getting a lawyer now, but you can't put the horse back in the barn. It's done. It's gone. He's got that. He wasn't there to preserve issues for appeal. Now, there might be some issues there that he can still appeal, that the Court of Appeals might say, yeah, the trial shouldn't have continued without the defendant present, or whatever. That is a possibility, but it's not a good possibility. One of the procedural rules is that if you don't preserve an issue for appeal, you can't appeal it. If you don't make the argument at the trial court, if you don't make the objection at the trial court, you can't appeal it. That's a rule. There are some exceptions to it, but that's a rule. And if you don't understand it, and if you don't prep the record by making the proper objections at the proper times, again, you hurt your risk of success. So I know sovereign citizens aren't going to listen to this, but I felt like I should say it. Thanks for watching. Have a great day.